Hello everyone, I am Dr. Rashmi Nagpal, presently Dean, Geeta Institute of Law, Panipat. Our institute is affiliated to Kurukshetra University and approved by Bar Council of India. I am here to give you a presentation upon the lesson 1 of Constitutional Law of India, that is Preamble, Constitutionalism and Constitutional Interpretation. This is the preamble, as we all know, is an important document of the Constitution. It embodies the fundamental values and the philosophy on which the Constitution is based, and also the aims and objectives which the founding fathers of the Constitution enjoined the polity to strive to achieve. Here there are certain norms and the fundamental values which the framers had in mind, which the Constitution seeks to establish. The importance and utility of the preamble has been pointed out in several decisions of the Supreme Court. Though by itself it is not enforceable in any court of law and does not constitute an operative part of the Indian Constitution, yet it is an important document and has several important purposes. As we have already studied, that it is representing the whole structure and the fundamental values of the Constitution, aiming and also aims the objectives and the aims of what the founding fathers of the nation wanted our country to be. The preamble was adopted on 26 November 1949. When it was designed initially, it described the state as sovereign democratic republic. In 1976, at the time of emergency in India, the 42nd Amendment described the state as the sovereign socialist secular democratic republic. Two words, socialist and secular, were added by way of 42nd Amendment 1976. The text of the preamble reads as, "We, the people of India, having solemnly resolved to constitute India into a sovereign socialist secular democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the state." In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves this Constitution. These words are of prime importance, which state that the people of India adopt, enact and give to themselves this Constitution. It serves two purposes. It indicates the source from which the Constitution derives its authority, also states the objects which the Constitution seeks to establish and promote. It seeks to establish what Mahatma Gandhi described as the India of my dreams, stating, "An India in which the poorest shall feel that it is their country in whose making they have an effective role, effective voice. An India in which all communities shall live in perfect harmony. There can be no room in such an India for the curse of untouchability or the curse of intoxicating drinks and drugs. Women here will enjoy as the same rights as the man." This was what the vision of Mahatma Gandhi was. It declares that it is the people of India who had enacted and adopted and given the Constitution to themselves. Thus, the sovereignty lies ultimately with the people. It also declares the ideals and aspirations of the people that need to be achieved. Ideals, we all understand, are different from aspirations. while the former have been achieved with the Constitution, proclaiming India as sovereign, socialist, secular, democratic republic, and the later, that include justice, liberty, equality, and fraternity, which are yet to be achieved. The ideals are the means thereby to achieve aspirations. Certain features of the preamble that are important for this study are the source of constitutional authority, describes the nature of the state, the objectives of the Constitution are enshrined in the preamble itself. Source of constitutional authority means 1. That sovereignty and ultimate power rests with the people. 2. The framers of the Constitution were the representatives of the people while drafting the Constitution. They were not directly elected representatives of the people, but elected under Cabinet Mission Plan during British rule on the basis of restrictive franchisee. The populance of the preamble shows that how effective it is. It has been accepted by the people since years together. The will of the people is the basis of the Constitution. It describes the nature of the state, whereby India is sovereign, socialist, secular, democratic republic through this preamble. The word sovereign means that it is supreme or independent. India is internally and externally sovereign, which means externally it is free from the control of any foreign power, and internally it has a free government which is directly elected by the people and makes laws that govern the people of India. Then the state authority of India is supreme over all men and all associations within India's territorial boundary. This is India's internal sovereignty. Externally, when we say that India is free from all external controls, India's membership of the Commonwealth or of the United Nations does not impose any external limit on her sovereignty. The Commonwealth is a free association of all sovereign nations. It is no longer British Commonwealth. India does not accept the British Queen as the head of the state. As Pandit Jawaharlal Nehru once pointed out, India has joined the Commonwealth by her free will. As for the UN, it is not a super state, but a club of free nations. Membership of the UN in no way limits the authority of sovereign states. On the other hand, this membership is a mark of sovereignty of state, for only sovereign states are admitted to the membership of the United Nations. Again, secularism is a glaring necessity in India's social political context. The object of insertion, a major object of secularism, was to spell out expressly the high ideas and compulsive need to maintain the integrity of nation, which are subject to considerable stresses and strains, and vested interest have been trying to promote their selfish interest to the detriment of public good. That India is a secular state will not mean that India is non-religious or irreligious or anti-religious, but simply that the state in itself is not religious and embodies the ancient principle of Sarva Dharma Sambhava, meaning thereby that the state shall not discriminate against the citizens in any way on the basis of religion. The word socialist was added to the preamble by the 42nd Amendment. It implies social and economic equality. Social equality in this context would mean the absence of discrimination only on the grounds of caste, color, creed, sex, religion or language. It is an important feature of the preamble. Under social equality, meaning thereby everyone has equal status and opportunity. Economic equality in this context would mean that the government will endeavor to make the distribution of wealth more equal and provide a decent standard of living for all. This is in effect emphasized a commitment towards the formation of a welfare state. India has adopted a socialistic and mixed economy, and the government has framed many laws to achieve this aim. The reason that glaring disparity in income distribution induced the government to control the commanding heights of the economy in the interest of suffering masses. This is the reason that right of property, private property, one of the fundamental rights enshrined in Article 19, had to be removed from the list of fundamental rights through a constitutional amendment, thereby securing the ideal of socialist economy. When we talk about a secular state, the word secular, by inserted into the preamble again by the 42nd Amendment, implies equality of all religions and religious tolerance. No state religion, every person has the right to preach, practice and propagate any religion they choose. The government must not favor or discriminate against any religion, must treat all religions with equal respect. As we have discussed earlier, all citizens, irrespective of their religious beliefs, are equal in the eyes of law. No religious instruction, again to secure secularism, is to be imparted in government or government aided schools. Next feature, which is an important one, that India is a democracy. The people of India elect their governments at all levels, be it the union, state and local level, by a system which we all know is the universal adult franchise, popularly known as, in our country, one man, one vote. Every citizen of India who is 18 years of age and above, and not otherwise, who is not otherwise debarred by law, is entitled to vote. Every citizen enjoys this right without any discrimination on the basis of caste, creed, color, sex, religion or education. By republic, we have included this word in the preamble, that India is a republic. A system is a republican, we call when no office of the state is held on the basis of hereditary prescriptive rights, meaning thereby that in India every office of the state from the highest to the lowest is open to every citizen. Any citizen may occupy any office on the basis of merit. Thus, the headship of the state is not hereditary as in England, nor is it based upon any military power as in dictatorial regimes. India has qualified to be a republic. Here, the president is indirectly elected by the people for a fixed tenure, and he makes use of this power on the advice of Council of Ministers, which is responsible before the Lok Sabha, which is the House of People's Representative, who come directly elected by the people on the basis of universal adult franchise. In India, we want to achieve the objectives given in the preamble. The first and foremost is to secure justice for the people of India so that they are able to make development of their personality. This ideal of justice implies a system where the individuals can realize their full potentialities. In view of our founding fathers, it is not enough that there is political or legal justice. Political and legal justice is a myth unless and until it is accompanied by social and economic justice. Political justice in India is guaranteed by universal adult suffrage without any sort of qualification. while social justice is guaranteed primarily through the directive principles of state policy. Social justice implies that all social discrimination like the discrepancies in caste and untouchability must be ended. Another important objective is to secure the liberty. The liberty which can be of different kinds: liberty of thought, expression, belief and faith, worship. All people of India have the right to express their faith, to express their expressions. They have the liberty of thought and to worship whatever religion they feel like following. This is that enshrined in Article 19 of the Constitution, guaranteeing liberty to the people of India. Equality is another important objective laid down in the preamble. Equality would mean India wants to ensure that preamble, the feature of the preamble, thereby ensuring equality feature, is to ensure equality to all, which would include: one, that it is equality of status. The Constitution of India ensures equality of status to all. According to Article 15, the state shall not discriminate against any citizen on ground of religion, race, caste, etc. Then is the equality of opportunity, whereby Article 16 of the Constitution clearly mentions that equality of opportunity will be provided for all citizens in matters relating to employment or appointment to any office under the state. To promote fraternity is another important feature of the preamble. It stresses to promote fraternity among the people of India so that they are able to rise above the narrow feelings of communalism, linguism, regionalism, provincialism, racism and casteism. The purpose is to adopt the ideal of universal brotherhood, thereby curbing hatred amongst the people of all nations. It ensuring the dignity of the individual, one. Two is ensuring the unity and integrity of the nation. The Constitution, we all know, was adopted on November 26, 1949 by the Constituent Assembly and was enforced on January 26, 1950. Next important question that arises with regard to preamble is it a part of the Constitution, and what do we mean by the basic structure? The word basic structure has not been defined in the Constitution. It is only through judicial pronouncements that we know what is basic structure and what is included in basic structure. The Supreme Court in Keshwananda Bharti versus State of Kerala, 1973, overruled its earlier decision of Re-Beruberi case, 1960, and made it clear that it is a part of the Constitution and is subject to the amending power of the Parliament as any other provision of the Constitution, provided the basic structure of the Constitution as found in the preamble does not get disturbed. Significance of the preamble. Constitution of India in its preamble reflects the basic structure and the spirit of the Constitution, though the word basic structure has not anywhere been used in the Constitution or in the preamble. It is regarded that the preamble serves as a channelizing tool for the interpretation of the Constitution as a whole. 2. Preamble acts as the preface to the Constitution of India and lays down the fundamental values and philosophical ideas. It represents the entire Constitution in written words. Next is another significant feature is that it contains the basic features of the Constitution and considered to be a vital part of it. It is significant because it highlights the type of society and the government it wishes to establish. However, we can say that it does not contain, the preamble does not contain the laws enforceable in a court but no law can be enacted or amended in a manner that violates the spirit of the preamble. Thus, the preamble of the Constitution, we can say, is unamendable and unalterable. What is constitutionalism is another basic point in this lesson. First is that modern political thought draws a distinction between what is constitution and what is constitutionalism. The underlying difference between the two concepts is that a constitution ought not merely to confer powers on the various organs of this government, but also seeks to restrain those powers. Constitutionalism, on the other hand, envisages checks and balances and putting the powers of legislature and executive under some restraints and not making them uncontrolled and arbitrary. Unlimited powers, we all know, always jeopardize the freedom of the people. Constitutionalism, we can say, is the antithesis of arbitrary powers. The antithesis of constitutionalism is despotism and in essence connotes limited government or a limitation on government. Thus, we can say that a written constitution, independent judiciary with powers of judicial review, the doctrine of rule of law and separation of powers, free elections to the legislature, accountable and transparent democratic government, fundamental rights of the people, federalism and decentralization of power are some of the principles and norms which promote constitutionalism, a very important feature of our country. Coming to what is constitutional interpretation, the basic question here arises whether judges make law or they only declare the law already existent. As per the orthodox view that we followed for years together is that judges only declare what is given in the text, that is, they do not make law. Well-established rules of interpretation require that the meaning and intention of the framers of a constitution, be it parliament or a constituent assembly, must be ascertained from the language of that constitution itself. With the motives of those who formed it, the court has no concern. Then is the literal versus liberal approach. In the C.P. Berar Act 1938, popularly known as the Central Provinces case, after quoting the observations of Lord Wright in James versus Commonwealth, that a constitution must not be construed in a narrow or pedantic manner, and that construction which is most beneficial to the widest possible amplitude of its powers must be adopted. It said that a broad and liberal spirit should inspire those whose duty is to interpret the constitution, but it does not imply that they are free to stretch or to pervert the language of the enactment in the interest of any legal or constitutional authority, theory, or even for the purpose of supplying omissions or of correcting the supposed errors. Then the Pramati Educational and Cultural Trust versus Union of India is a famous authority on the case. In this recent case, which is popularly known as Pramati, on constitutional interpretation, the bench upheld the constitutional validity of the right of children to free and compulsory education, Act 2009, popularly known as RTE Act. This being a reaffirmation of the court's earlier decision that was pronounced in 2012 in the Society for Unaided Private Schools of Rajasthan versus the Union of India and others. The second part of this Pramati judgment exempts all minority institutions from the RTE. This is an expansion of the ambit of exemption from society case, which had limited it to unaided minority institutions only. Minority institutions here refer to both religious and linguistic minorities as referred to within the constitution. Then the case of Aruna Roy versus Union of India on Article 28 Clause 1 of the Constitution came up for interpretation. As in the national curriculum prepared by the NCERT, study of religions was sought to be introduced in the state-aided institutions. Prohibition on religious instruction under Article 28 Clause 1 of the Constitution came up for consideration before the court. It was held the expression public religious instruction used in Article 28 Clause 1 has a restricted meaning. It conveys that the teachings of customs, practices relating to religion, rituals, and the ways of worship in educational institutions wholly maintained out of state funds is not allowed. But Article 28 Clause 1 cannot be read as prohibiting the study of different religions existing in India and outside India. If that prohibition is read with the words religious instruction, study of philosophy which is necessarily based on study of religions would be impermissible. That would amount to denying children a right to understand their own religion and also the religion of others with whom they are living in India and with whom they may like to live and interact. Study of religions, therefore, is not prohibited by the constitutional provisions and in the Constitution. It should not be read so. We can say that a court of law, in other words, must gather the spirit of Constitution from the language used, and what one may believe to be the spirit of Constitution cannot prevail if it is not supported by the language, which therefore must be construed according to well-established rules of interpretation. Uninfluenced by an assumed spirit of the Constitution, where the Constitution has not limited, either in terms or by necessary implication, the journal powers conferred upon the legislature, the court cannot limit them upon any notion of the spirit of the Constitution. Since we know that Constitution is the supreme law, it lies upon the courts to determine the meaning and scope of the law or action. As interpreters or the arbiters of legal disputes, they have to tell what the law is. In doing so, we believe that they give due regard to the powers and autonomy of the other organs, particularly of the legislature, whose purpose is to make laws. The courts presume that the legislature acts are all constitutional unless proved otherwise. But the cases are not always clear, and therefore the cases are not always clear, and therefore an unending debate continues on the role of the courts in judging the validity of these laws, particularly of the Union Parliament. Next is that interpretation by courts becomes necessity for the protection of individual rights guaranteed by the Constitution for the growth of Constitution itself, and is like an institution protecting and upholding enduring values enshrined in the Constitution. The law creative function of the judges is well recognized now in the modern contemporary world. A judge has his own scale of values and makes choices according to that. If one interpretation of law leads to unjust results, as we have seen in the case of Aruna Roy, and another to just results, nothing prevents a court from adopting the later construction. This is the purposive rule of interpretation, that the Constitution is interpreted in such a manner which is a liberal, a purposive construction, a purposive interpretation to serve what for the Constitution and the preamble was framed. Not everything is explicitly given in the Constitution. By way of interpretation, the judges have been able to enlarge the preview of certain provisions of the Constitution, giving it the widest possible ambit, then is influenced by these judicial attitudes. There have been two approaches. One is to the interpretation of written Constitution. One is the literal approach, which is a mechanical, narrower interpretation of the Constitution, where the judgment constitutes only about the text, the exegesis of the fundamental text, that is we call as the literal approach. The other, which is followed now, is the liberal, purposive, law-creative interpretation of the Constitution, with the premise that the Constitution, being the fundamental law of the land, should be interpreted more liberally than an ordinary statute. Lastly, is the sum up of our discussion today is the need of the hour is to adopt an integrated approach in the interpretation of the Constitution in the light of social, economic, political necessities of a particular period in which the court is called upon to interpret. We have seen the features of the preamble. The preamble enshrines what the founding fathers of the nation had in view. The country must adopt that. The interpretation by courts should be such that makes the Constitution a workable law or an instrument by treating it as a dynamic living document which needs to be suitably interpreted to meet the exigencies of the modern world today. Thank you.